your defense to the termination? There's a month-to-month lease, correct?
This opening instantly sets the stage for what is more than just a landlord-tenant spat. The defense begins with the key point: there is no long-term lease, just a month-to-month arrangement. That distinction is huge. Why? Because under most landlord-tenant laws, a month-to-month tenant has fewer protections and can often be asked to leave with proper notice, unless they can establish a legal exception. But listen carefully. The defense is not denying the lease terms. Instead, they immediately pivot into a personal narrative: decades as a reliable renter, a history of paying bills, and then the hammer blow of illness and financial collapse. It's an emotional strategy meant to frame the defendant as sympathetic, hardworking, and blindsided by tragedy.
Well, there was a change in agreement as well, Your Honor, and history and backstory that is very much applicable to this situation. I would like to first bring to your attention that I'm a lifelong, long-term renter. Residentially, longest term 13 years, and 8 years. Commercially, I leased an upstairs office at Nichols Arcade from Wilson White Management at that time for 15 years. I have never had a problem paying my bills or until COVID, and which I contracted in fall of 2019, which began a horrendous downhill slide of health, illness, income, and has basically rendered me indigent at age 68. I have tried to get help from agencies, and I have not even heard back from Hawk as to, after my appointment on Monday, as to, how things went. There are many issues beyond what is apparent on the ledger sheet. And when I initially agreed to move into this home, I had another one lined up as indicated previously in our hearing. I requested to stay only 3 months. The plaintiff demanded 6 months because she needed me to watch her home while she and her husband, the landlord, went to Florida for a very long vacation, over 6 weeks, I believe it was, in 2020, beginning of 2022. Problems arose right at the...
Ma'am, can I just stop you one moment?
Absolutely.
All right. This is filed as a termination action. And fundamentally, the issue is going to be, because of there is no lease, is going to be, why shouldn't you move?
This is where Judge Simpson cuts right through the fog. He isn't dismissing the defendant's story, but he zeroes in on the actual legal question: possession. Not illness, not history, not sympathy, possession. In landlord-tenant disputes, judges are often bound by the letter of the lease and the rights it gives the property owner. Notice the contrast here. While the defendant focuses on her personal hardships, Judge Simpson redirects back to the law's simplicity: no lease, no right to stay. This is a pivotal turning point. Legal reality is colliding with emotional appeal. Viewers, do you think the judge should take her hardships into account here, or should the case be decided strictly on the legal merits? This is where law and morality can feel like they're in direct conflict.
Your Honor, I've been before you previously, and I have 3 functional disabilities: electrohypersensitivity, which makes me incompatible with any of the wireless utility meters, internet, Wi-Fi, cell towers, etc. This home has also been mitigated for me with the acknowledgement and cooperation of the landlords, who years prior to my tenancy, had replaced the utility meters with opt-out meters when I made them aware of all the issues of electromagnetic frequencies. They have Ethernet installed, and we had things mitigated to reduce the interference of electricity and wireless devices, including Stetzer filters in the plugs of electrical plugs of the home, which was also by verbal agreement. My loan to them on their above floors for the use of the landline digital cable phone, and that which has been denied to me and does not allow me to send more information to the court. My impression from the papers that I was given, and as I indicated in the prior hearing, Judge Barr had said other ones needed to be entered that apparently were not needed. This is collection and termination. Had I had my phone line not turned off to me after I faxed in the confidential contact information requested by the court, I would have been able to send to you a letter from Ms. Peel that she wrote to the Department of Health and Human Services when I applied 3 years ago in 2020, stating that, you know, I was in dire financial circumstances and having problems paying rent with the prior landlord. I did not know at that time I had long COVID. It was also the plaintiff who did the research and informed me.
Here, the defense introduces outside documentation, letters from health and human service agencies, medical hardships, proof of financial struggle. It's a smart move because courts weigh credibility, and bringing in third-party evidence reinforces her story. But here's the catch. Even with proof of financial hardship, that doesn't create a legal defense to possession. Judges can sympathize, but unless statutes provide an explicit defense, like protections against disability discrimination or specific COVID-era moratoriums, the argument is emotional, not legal. Judge Simpson's body language here matters too. He listens but repeatedly pulls the case back to the possession question. For viewers, this raises a critical issue. Should evidence of vulnerability ever outweigh contract law? Would you want courts to protect someone in her situation, even if it means the landlord loses money? Or is that a dangerous precedent that undermines property rights?
In late spring of 2022, but they have awareness of all my frailties and vulnerabilities, which they have not been honoring in any degree, and knowing how very difficult it is for me to find a safe place to live, and I'm going to have to move rurally. There is no housing, affordable senior housing, etc. I can be in because of everybody else's need for wireless devices, which are beyond hazardous to me. I suffer from post-traumatic stress disorder from a car accident where when I requested aspirin, they wouldn't give it to me, but narcotics and opiates that were not compatible with me, and a closed head injury that was not diagnosed for a year and a half. So I have 3 strikes against me just as a person functioning in the world with the long COVID, the electrohypersensitivity, and the PTSD. I have been subject to some very harsh, intrusive, invasive treatment as a tenant here for some time prior to these recent occurrences. And the assumption that one has of autonomy, privacy, and enjoyment of property when renting a property have also been denied me.
Okay,
I
Ms.
live
Gerler,
as
Ms. Gerler,
Yeah.
I'm going to stop you for a moment, okay?
Sure.
Those aren't a basis for me not to grant a judgment to the plaintiff.
Judge Simpson delivers a blunt reality check. Sympathy does not equal legal standing. This moment illustrates the cold, mechanical side of law. You can hear the judge's tone, firm, almost cutting. He acknowledges her struggles, but he clarifies that none of it changes the legal foundation. For the plaintiff, this is a relief. They hear the judge pivot toward their side. For the defendant, it's crushing. And for us, it's the moment where the case starts tipping. Judges often do this deliberately, lay out the limits of the law so both parties understand where things are heading. Viewers, think about this. Have you ever seen a situation where someone's personal story was heartbreaking, but the rules didn't allow flexibility? Should judges be strict interpreters of the law, or should they use discretion to balance humanity with legality?
Or at least possession. The issues that you're talking about may relate to their monetary claim. But as to the issue of possession, why shouldn't the landlord get their property back? Let me try to put it that way.
Your Honor, I was under the impression that Hawk and other agencies would be assisting me with the back rent so that I would have time to find a suitable place, because I will literally be on the street with my possessions. I would say that would be today's equivalent of delivering a head on a plate. I have nowhere to go. I have no vehicle. I live as a virtual shut-in with restrictions.
Okay, I understand that. Your name, ma'am?
Pamela Pia.
Okay. Ms. Pio, you've heard all of the circumstances. You're aware with this defendant. How much time would you give her to vacate the premise?
Your Honor, I have asked her to pay up or move out since June of 2022. I am a very kind-hearted person. I was aware of the circumstances.
Now the spotlight shifts. The landlord finally voices her side, and listen to how different the tone is. Measured, factual, but also weary. She's in her 70s, dependent on this rental income, and says she carried the tenant for over a year. This is the other emotional weight of the case. On one hand, you have a struggling tenant with medical and financial hardships. On the other, a landlord barely scraping by, watching her own bills pile up because rent isn't being paid. This isn't a rich corporate landlord. It's a retiree trying to survive. That's why Judge Simpson emphasizes the unpaid balance, $11,995. That's not just a number. It's months of bills, groceries, and daily survival for the plaintiff. Viewers, here's the tough question. When two vulnerable people collide, one sick and homeless, the other elderly and financially strained, who should the law prioritize?
However, this whole thing, I'm in my 70s. I depend on my rent for paying my bills. And I kept asking her, hoping, praying that she would leave. And she was unable to do so. And I can no longer carry her on my back.
All right.
Literally, it's.
I hear you, and I understand because of the pretrials in this case, where this case was. So how much is owing?
The amount of rent owing is $11,995. That's about.
Okay, right. So the problem for both of you is, even if, Ms. Gerler, and just listen to me, even if Hawk were to assist you, given what their maximum amounts that they would be able to assist, you'd still have to come up with $9,000. Okay? So there's part of that's the big issue. So when
Your
we
Honor,
get to that,
pardon me.
pardon?
I would just need to inquire about those figures because when I spoke with Autumn on Monday, she said that they had, I believe, a maximum of $5,000 they can issue. She was going to reach out again to Faith in Action for me, whose monies Ms. Peel, the plaintiff, declined in July of 2022, and at that time, other affiliated agencies would have brought me current there was $2,985 owing, but because the plaintiff refused the offers of money, that other monies were not forthcoming. And the plaintiff also knows I have been sequentially ill on a regular basis. There's no soundproofing between the downstairs, upstairs. They hear me hack, cough, sneeze.
Ma'am?
So
Ma'am.
I'm letting you
Ms.
know
Gerler,
it is illness, chronic illness. Yes.
Ms. Gerler. Whether it's 5,000, 3,000, we can get into that argument, but you'd still have to come up with the other 7,000 if it's 5,000. I mean, the problem is that those other amounts are going to be your difficulty.
Your Honor, I don't believe that I should be culpable and responsible for the monies they declined in July 2022, the $2,985, which would knock the equivalent of $3,000 off of the total. When I spoke to Autumn, she said that she would also pursue with Faith in Action. I was denied by Department of Health and Human Services for reasons I don't know, because my mail is being held and I have not gotten that back to me. When you're only making $1,100 a month on Social Security, I don't know why I was denied, Your Honor. I can no longer work. I was self-employed.
I understand that, Ms. Gerler. Ms. Gerler, I understand all of that. But when we all boil it down, the reality is the funds aren't there.
This is where the hammer drops. Judge Simpson simplifies everything into one unshakable fact. The money doesn't exist. The defendant can argue about grants, agencies, denied benefits, and bureaucratic delays, but at the end of the day, she owes more than she can ever repay. This is the law distilled to its core, contracts and obligations enforced by the ability to pay. Watch his pacing here. He carefully lays out the numbers, stripping away the noise until the situation is undeniable. This is also a teaching moment for viewers. Judges aren't there to rescue either party. They interpret the law and enforce obligations, no matter how unfair it feels. Question for you. Do you believe courts should offer more structured protections for people who fall into these can't pay, can't stay situations? Or does that risk breaking the entire rental system?
And so if the funds aren't there, what's really going to end up happening is you're going to have to move. As I see it, and I'm looking at the case, it isn't a matter of whether or not you will have to, it's a matter of when.
And I would ask that the landlords, knowing my circumstances and situation, please grant some lenience in this case, as they may be leaving at the end of the month to go on a 2-month Florida vacation. I have tried even to get people to help me pack, and people are not available due to our upcoming holiday. I am at this point.
Okay, Ms. Gerler, let me ask you this.
I'm weak.
Ms. Gerler, in your mind, how much time do you need to move?
To be very
Not
realistic.
saying I'm going to give you that much time. How much time, when could you be out?
To be realistic, sir, requiring the assistance and the fact that I may move very far away, I would likely need till the end of January because I have quite a bit of things to take with me.
Okay, so you need to the end of January.
This is the human plea at its rawest. The defendant isn't talking law anymore. She's begging for time. End of January, she says, because moving with disabilities, no car, and limited help is impossible overnight. It's a classic tenant strategy. If you can't win the case, at least fight for more time. Notice how Judge Simpson handles this. He doesn't argue the hardship. He listens, then turns to the landlord for flexibility. This is a balance. Judges must strike, enforce the law, but soften the blow where possible. For viewers, here's the big tension. Does justice mean strict enforcement, or does it mean compassion in execution? If you were the landlord, would you grant her until January, knowing every day cost you, or would you cut the cord immediately?
Yes.
Ms. Peel, would you give her to the end of January?
Consult with my husband for 1 minute.
You look like the brain trust, but yeah, go ahead. You can talk.
Would be willing to do January 15th.
Okay.
Here we see negotiation live in court. The landlord offers January 15th, a middle ground. It's not the full extension the tenant wanted, but it's also not an immediate eviction. Judges often encourage this give and take because voluntary agreements reduce appeals and future disputes. But the defendant immediately rejects it, saying it's impossible. This shows another courtroom reality. Compromise requires both sides to bend, and sometimes that just doesn't happen. Watch Judge Simpson's patience here. He doesn't force a settlement but keeps probing. He knows he'll make the final call, but giving the parties a chance to meet halfway creates a perception of fairness. Viewers, ask yourself, is compromise always the best outcome in these cases, or does dragging it out just create more suffering for both sides?
So you won't do
Your Honor,
January.
that's not possible. I apologize for interrupting. It's not possible, sir. Yeah.
Ms. Gerler, hold on.
Yeah.
Anybody have anything else to say? Before I give you my ruling.
Your Honor, if there was anything else beyond hold on, I did not hear it. This is.
No, okay. I was just asking if anybody else wanted to say anything else before I issue my ruling.
Your Honor, I would like to say, if it is possible, they hold $995 in as a security deposit, which they could keep for the month of January if I were allowed to stay. And of course, we'll continue to look for additional help, but to pay. But they know my circumstances, and
Yes, they do, Ms. Gerler. So here's what I'm going to do. I don't think that there's really much distinction between the 15th and the 31st. And given your circumstances, Ms. Gerler, I'm going to grant a judgment to the plaintiff for possession. The writ will not issue till January 31st, 2024. There is an issue regarding, you're welcome, but there is an issue regarding monies that would be owed.
This is the defining ruling. Judge Simpson grants possession to the landlord, but gives the tenant until January 31st to vacate. That's a huge concession, more than the plaintiff wanted, but it reflects the judge's sense of fairness in light of the tenant's age, disabilities, and circumstances. Notice his careful wording. The writ will not issue until January 31st. That means no physical eviction until then, but it also sets a clear, immovable deadline. The gavel drops, and the drama shifts from if she must leave to when she must leave. This is classic judicial balancing. Property rights prevail, but humanity is acknowledged. For viewers, think about this. Did Judge Simpson strike the right balance here? Too lenient, too strict, or just enough to keep both parties from total collapse?
And so a trial on any additional monies that will be owed will be set for March 5th, 2024 at 9 a.m. in person. That will give time. The reason I'm setting it out to that date, that will give time by the time she vacates the premises to then you can do the inspection and you can have all of the damages that we can figure out and hopefully have it told. All right. Any questions from
Your
either?
Honor, the only comment that I have to say, and I'm very sorry, but I cannot appear in person. I can only appear via remote Zoom
All right.
due to my disability.
I understand that, ma'am. All right. Yes, ma'am.
Your Honor, you have struggled getting into for many months now. Since I asked her to leave, pay up or leave from the possession that I filed a few months ago, October. The tenant has not paid us any rent, and she will not let us have access to our mechanical room, which unfortunately is, we have to have access to the mechanical room through her apartment.
This late-stage testimony adds another layer of friction. The landlord isn't just owed money, she says she's been denied access to essential parts of her own property, like the mechanical room. That's not just inconvenient, it's legally significant. Landlords generally have the right to access utilities with reasonable notice. Blocking that can be seen as interference with property rights. Judge Simpson responds pragmatically, 48 hours notice, access must be granted. It's a straightforward solution, but it highlights how even small details like access to a boiler room can become battlegrounds in eviction cases. Viewers, here's the question. Do you think the defendant was reasonably protecting her privacy or unfairly restricting the landlord's rights? These micro-conflicts often reveal the deeper mistrust that makes disputes like this so bitter.
And we give her notices, and then we have people come and she will not, oftentimes won't answer the door or will just say, you know, whatever excuse, and then we have to continually deal with it. That's why I really didn't want to extend the time, but I understand your perspective. It's been very difficult dealing with her. And
This is not great.
Looking forward to this being completed, and I just want to, we do want access to our.
All right. Under paragraph 10, when you fill out. Yes, Ms. Gerler.
I would like to respond to that, please.
Which part?
The part about them wanting access to their mechanical room, or access to the apartment. I have been subjected to an increasing amount of hostile, threatening, aggressive action, pounding on the door.
Ms. Gerler. Ms. Gerler.
I would allow them in to do whatever they need to do, but not by myself, with someone else. I have not resisted them. I have been literally ill when they wanted to come in.
Here's, Ms. Gerler, here's what I'm going to do. On the judgment form, when you fill that out at the counter, under paragraph 10, the defendant is to allow plaintiff access to the mechanical room upon 48 hours notice. Ms. Gerler, that will give you time to get somebody there. That's adequate notice that you, if you're going to have somebody else go in and look, you got the time to do it.
Your Honor, that is totally fair, and I
thank you. That's what I do.
I'm very impressed with you, Your Honor, so thank you.
Well, thank you, Ms. Gerler. I appreciate that.
Will you put that in writing, or do I need to?
You need to write that under paragraph 10 on the judgment form when you pick one up the front.
Okay. And what exactly do I have to say again?
Defendant, you know what? Go fill out the judgment form. I'll put it under paragraph 10. I got it. Okay.
I actually have it filled out, but this, it wasn't just for possession. This was.
There's a money portion of it too. It's, you wanted possession and you want a money judgment Or
So I can give you both of those.
you can give me the judgment form. The money judgment piece I've adjourned to March.
Okay, so then I don't fill out the money piece. All the rest is,
Do you have the,
I have a form. I didn't expect it.
okay, put the names on there, I'll fill the rest out.
Okay,
All right,
thank you.
thank you. Thank you, Ms. Gerler, and both of you have a very happy holiday.
And there it is. The case winds down. Judge Simpson grants possession to the landlord effective January 31st, sets a future trial date in March for the financial claims, and ensures the landlord will regain access to her property. Both parties walk away with something. The landlord secures her rights. The tenant gets a grace period. But the bigger story here is the system itself. Cold contracts intersecting with human struggle. This wasn't a clash between villain and victim. It was two vulnerable people, one elderly, one sick, caught in a legal machine that doesn't bend easily. For viewers, it's a reminder that behind every eviction is a human story, but also a landlord relying on law to survive. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.